The duty of loyalty, or the obligation of loyal cooperation, has also a constitutional dimension. Beyond the obligation not to jeopardize the specific objectives or the external action objectives of the European Union, there is a constitutional dimension linked to the autonomy of the legal order of the European Union. The internalization of the allocation of responsibility is an expression of this obligation not to allow an external body interfere with the division of competences. This is linked to the principle of autonomy. Keep the division of competence an internal EU law question. So there is a constitutional dimension of loyalty which meets the objectives dimension, the more substantive dimension. Because of the constitutional dimension to keep the division of competences internal, there is a joint responsibility which in its turn implies the duty of loyal cooperation to ensure the implementation of a mixed agreement as a whole. So constitutional dimension or substantive dimension with specific obligations of the duty of loyal cooperation meet each other. The question that we will discuss now is the more precise link between loyal cooperation and autonomy. In other words, the question is what is the basis of the principle of autonomy? Is there a principle of autonomy? Does the duty of loyal cooperation cover the obligation to respect the autonomy of the EU legal order, or it is just the expression of the autonomy, the loyalty obligation to preserve the characteristics of the EU legal order? This is what we call autonomy. So we will discuss this question because the issue of autonomy of EU law and of the EU legal order is raised with a particular interest in the context of the new generation of free trade agreements and in the context of the dispute settlement provisions of the free trade agreements. As we already mentioned, and you already discussed and you probably know, there is a pending opinion addressed by the Belgian government to the Court of Justice concerning the compatibility of the ISDS provision, Investor State Dispute Settlement provision of the CETA agreement with the autonomy of the EU legal order. So what exactly means autonomy? Autonomy is not something special for the European Union, but concerns each international organization. There is an internal dimension of the autonomy, which means that the international organization is autonomous with regard to its members. In the EU legal order, we know the classic decisions, Van Getten Laws, Costa and Nel, which established an autonomous legal order, which is the EU legal order integrated in the legal orders of the member states. So there is this internal dimension of the autonomy, which means that EU law is to be distinguished from national law, prevails over national law, but at the same time is integrated in national law. We have a multi-level system of implementation of EU law. So this is the internal aspect of autonomy, which concerns also other international organizations, because an international organization has a legal personality, so is to be distinguished from the member states, is to be autonomous from the member states. This internal dimension of the autonomy, the union with regard to member states, takes expression of the fundamental structural principles such as primacy, direct effect, effectiveness, and a more precise principle of regulation of exercise of competences, confer all principles which are structuring the functioning of the EU legal order are part of the autonomy, specific characteristics. So autonomy means preserve the specific characteristics in the EU legal order, but also with regard to international law. So there is also an external dimension of the autonomy, where in the European Union there is a question of balance between the objective to be an international actor, which implies the specific obligation, according to Article 3, Paragraph 5 of the Treaty of the European Union, to respect international law. So there is the duty of deference with regard to international law, which is to be balanced with the principle of autonomy, the autonomy of the EU legal order with regard to international law. And we know the famous Caddy case, where the Court of Justice explicitly stated that the respect for international law that the European Union dues to the United Nations Charter does not mean that international law may intervene with constitutional principles such as fundamental rights protection. So the external dimension of the autonomy means that fundamental principles are to be preserved from interference of international law. Respect for international law from the point of view of the European Union is part of the specific characteristics because it is an objective of the Union. The Union has to respect international law. The Union has to implement international law obligations, but it is an obligation stemming from the treaty, and EU law is to be preserved from interferences from international law. In other words, what means autonomy? Autonomy means preservation of the fundamental principles of the EU legal order, containing values, comprising fundamental rights protection. This aspect of the autonomy preserve the fundamental characteristics of the EU legal order, comprises both the internal dimension in the member states and the external dimension with regard to international law. So autonomy means preservation of the fundamental characteristics of the EU legal order in the implementation by member states and with regard to international law. However, there is also an institutional aspect, an institutional dimension of the autonomy. Preserve fundamental principles, but who will ensure preservation of the fundamental principles of the EU legal order? And there we have the aspect of the autonomy, which is translated into the preservation of the exclusive jurisdiction of the Court of Justice to ensure the respect of the fundamental principles of the EU legal order. And there we have the issue of the interference of an investment tribunal, an arbitral tribunal, with the jurisdiction of the Court of Justice. So it is not so much intervening in the fundamental principles of the EU legal order, but it is about the institutional, procedural dimension of the principle, if we can name it principle, the requirement, the claim for autonomy of the EU legal order. It is not an autonomous principle, but it is the expression of principles which a procedural dimension respect the exclusive jurisdiction of the Court of Justice to ensure the preservation of the fundamental principles of the EU legal order. So it is in this context that we have the introduction, the requirement for an opinion of the Court of Justice with regard to the CETA dispute settlement provisions. We don't have the opinion for the moment. We will have the position of the Advocate General Board, which will be delivered on 23rd of October. So what we can say about this question will be based on what we have already in the case law of the Court of Justice, but without certitude. But we will see what is the position of the Court of Justice with regard to this autonomy claim. The Court of Justice has already taken position in previous opinions. We have opinion 191 concerning the EUA court, which is now the EFTA court, but initially it was provided in the European Economic Area Agreement that a common jurisdiction, an European Economic Area Court, would be established in order to interpret and apply the European Economic Area Agreement. The Court of Justice in 1991 considered that this was in conflict with the autonomy of the EU legal order. Why? Because the objective of the EEA agreement was to expand, to export internal market rules to the EFTA states, now Iceland, Norway, Liechtenstein, part of the EEA, European Economic Area. If we have a a common jurisdiction responsible to apply rules identical with internal market rules, then another body will interfere with the implementation and the interpretation of EU law. So the Court of Justice considered that it was in conflict with the principle of autonomy, and as a consequence, the EA agreement had been reviewed and the EFTA court has been established. A court concerning the implementation of this agreement, not a common court, but a court which will be responsible for the implementation, is responsible for the implementation of the EA agreement with regard to the EFTA states. In the European Union, there is the Court of Justice which applies the EA agreement. So there is no common jurisdiction which would interfere with the implementation of EU law in the European Union. This was considered to be in conflict with the principle, with the autonomy of the EU legal order. Another opinion we have is the opinion of 2011-109 concerning the establishment of a patent litigation system. The question was raised with regard to the autonomy of the EU legal order because a patent court would not have the same obligation as a national jurisdiction to refer a preliminary reference to the Court of Justice, and as a consequence it would be in conflict with one of the main characteristics of the EU legal order, the cooperation between the national judge and the European Court of Justice. Let's see, it is interesting to see with some more detail what was the position in opinion 109. The Court of Justice held that first of all, member states are obliged to respect the principle of loyal cooperation. So, in an opinion where autonomy is at stake, the court refers to the principle of loyal cooperation. So, we see a link between loyalty and autonomy already. So, the Court of Justice held that member states are obliged, by reason of the principle of sincere cooperation set out in paragraph 4, in Article 4, paragraph 3, to ensure the application of union law. The member states are to take any appropriate measure to ensure fulfillment of the obligations, and in that context, it is for the national courts and tribunals and for the Court of Justice to ensure the full application of European Union law in all member states and to ensure judicial protection of an individual's rights. So, the principle of loyal cooperation implies that EU law is implemented through the cooperation between the national courts and the European Court of Justice. And the court continued in the same opinion that the national courts, in cooperation, in the collaboration with the Court of Justice, fulfill a duty entrusted to them both, the Court of Justice and the national courts, to ensure the interpretation and application of the treaties and that the law is observed in the interpretation and application of the treaties. In other words, there is this specific characteristic of the EU legal order that the preservation of the principles of the EU legal order, so the implementation and the application of EU law, including the fundamental principle, is an obligation which is entrusted to both the Court of Justice and the national judge. So, who is responsible for the implementation and the preservation of fundamental EU law principles, the autonomy of the EU legal order, the Court of Justice, but with the national judge? It is a loyal cooperation of the member states to ensure this cooperation between the Court of Justice and the national judge to ensure the preservation of the characteristics of the EU legal order. This was already the position of the Court of Justice, which did not refer explicitly to the autonomy, but in literature we have the affirmation that it is about the autonomy of the EU legal order. The Court of Justice based its position explicitly to the duty to ensure preliminary reference, procedure and cooperation between the national courts and the Court of Justice. This autonomy claim is more apparent in opinion 213, concerning accession of the European Union to the European Convention of Human Rights. The Court of Justice referred to the obligation of the Member States to have recourse to the procedures for settling disputes established by EU law, in particular to respect jurisdiction of the Court of Justice, which is a fundamental feature of the EU system. So we have autonomy with regard to the fundamental principles of EU law, but also this procedural dimension, the Court of Justice has to ensure preservation of fundamental EU law principles. This is also part of the autonomy claim. Respect the jurisdiction of the Court of Justice. And this was the problem, one of the problems, concerning the accession of the Union to the European Convention of Human Rights. The Court said it is a specific expression of the Member States' more general duty of loyalty. In other words, we have the question, does autonomy stems from loyal cooperation? There is the duty of loyalty to ensure the jurisdiction of the Court of Justice, but at the same time, ensure the jurisdiction of the Court of Justice is part of the autonomy claim. This is autonomy. Ensure that it is for the Court of Justice to apply EU law and not from another court, even if it is the European Court of Human Rights. What about investment arbitration and investment treaties? How are these questions are to be discussed in this context? For the moment, we have only one element from the Court of Justice, and this element is linked to the question of competence. The Court of Justice already replied to the question of the competence to approve international investment dispute settlement provisions, which impacts on the autonomy claim, but did not explicitly deal with the autonomy claim. It is the topic of the 117 opinion that we're waiting for. Let's recall what is the position of the Court of Justice with regard to investment dispute settlement provisions as to the competence, which is also linked to the autonomy, because division of competence is one of the fundamental features of the EU legal order, so division of competence is part of the autonomy. So the Court of Justice dealt with this question in the 215 opinion concerning the EU agreement with Singapore. And the question, of course, as said, is pending because of the project to establish a permanent investment court in the framework of the CETA. Let's see what is the position of the court. Let's recall the position of the court in 215 opinion. First of all, the court underlined that the opinion concerns the competence of the Union to conclude the EU-Singapore agreement. After having dealt with the question of exclusive or shared competence with regard to the substantive provisions of the agreement, investment protection, transport, we discussed it yesterday, the Court of Justice discussed the institutional provisions. It held that institutional provisions such as transparency, judicial protection follow the division of competence concerning the substantive provision for which they are provided for. But what about dispute settlement provisions? The court held that as regards the competence of the European Union to approve Chapter 15 concerning dispute settlement, it should be recalled at the outset as starting point that the competence of the Union in the field of international external action and its capacity to conclude international agreements necessarily entail the power to submit to the decisions of the court which is created or designated by such agreements as regards the interpretation and application of their provisions. In other words, the European Union has the competence to participate in international dispute settlement. It is a necessary consequence of its competence to conclude international agreements. Another question is the bodies, dispute settlement bodies provided for, established by the agreements, have to limit themselves in the interpretation and application of the agreement and not of EU law, because there we will have a question of autonomy with regard to the court jurisdiction. Let's come back to the question of competence. So the competence of the Union to conclude international agreements entails the competence to submit to international dispute settlement bodies, the jurisdiction of which is limited to the interpretation and application of the international agreement. The Court continues. In the same way, the competence of the Union to conclude international agreements necessarily entails the power to submit to the decisions of a body, even if it is not a court, essentially, which essentially has judicial function, such as the dispute settlement body of the WTO agreement. So the competence is also to accept, to participate in a dispute settlement system. In paragraph 300 of the 215 opinion, the Court of Justice underlined that the present procedure, this opinion, does not concern the question as to whether investment dispute settlement provisions are compatible with the EU law. It does not concern the question of autonomy. It concerns only the question of competence. And the starting point is that if the Union has the competence to conclude an international agreement, it has the competence to approve the provisions concerning dispute settlement. So the Court is very clear. It is not appropriate to examine whether the dispute settlement regime of the EU-Singapore agreement fulfills the criteria set out by those others' opinions concerning the autonomy of the EU legal order. In particular, the criterion related to the autonomy of EU law. So it is something that the Court will not address. It will address in 215 only the question of competence, where the starting point is that substantive competence entails competence to approve provisions concerning dispute settlement. However, to continue with the position of the Court of Justice in Opinion 215, which limits its opinion to the question of competence, there is no opposition with there is no contradiction with the exclusive competence of the Court of Justice, because Chapter 15 of the Singapore Agreement relates to disputes between the European Union and the Republic of Singapore. So, as far as dispute settlement between parties is concerned, the Union and Singapore. Neither does this opinion cover the issue of the jurisdiction of the Court as far as it concerns settlements of disputes. So, it limits the opinion to the question of competence concerning, first, disputes between EU and Singapore. This dispute settlement regime concerning disputes between parties, EU and Singapore, follows the principle which is already recalled. It means that the competence to approve this kind of provisions follow the substantive competence. So the Court of Justice underlined explicitly that in the present procedure, it need only be stated that the dispute settlement regime forms part of the institutional framework for the substantive provisions of the envisaged agreement. Since that regime relates to disputes between the European Union and the Republic of Singapore, the rule laid down in paragraph 276 is applicable. It means that the competence to approve provisions related to disputes between EU and Singapore follows the substantive competence. It is an exclusive competence as far as the Union has exclusive competence. Dispute settlement provisions follow the substantive ones, it is a shared competence if it is related to the implementation of the provisions concerning non-direct investments. So there is no position of the Court of Justice as to the question, is it compatible with the autonomy, because there will be another tribunal, international body, which will intervene in the dispute between the Union and Singapore. This question is not addressed. But the competence is, the principle is that these provisions follow the substantive competence. However, the court took a different provision concerning no more disputes between parties, between Union and Singapore, but the investor-state dispute settlement, where there is a dispute between the investor and a member state. The EU-Singapore agreement provides for the possibility to have recourse to arbitration if there is a dispute between investor and member state. Once again, the court underlined that it will not deal with the question of the compatibility of this ISDS, investor-state dispute settlement provision, with EU law. What it is asked for is a question of competence. But there it took a different position. Instead of considering that it is also an institutional provision which follows the regime of the substantive provisions as far as competence are concerned, it took a different a different position. Why? It underlined that indeed, in the framework of such a system of dispute settlement, the claimant investor may decide to submit the dispute to arbitration without that member state being able to oppose it. What is the consequence? That dispute will not be submitted to the national courts. If we have a dispute between the investor and the member state, the first possibility is to address the claim to the national judge. But the ISDS provisions provide for the possibility to address the claim to arbitration. The question is not, once again, to know the extent to which such a provision is compatible with autonomy. The question is not to know if such a provision is compatible with the exclusive jurisdiction of the court. The question is to know who has the competence to approve this provision. Is it a provision which follows the regime of substantive provisions as to the competencies or not? And the court held that such a regime which removes disputes from the jurisdiction of the courts of the member states, because the investor may address the claim to arbitration, cannot be of a purely ancillary nature. It is not to be considered as an institutional provision, and cannot therefore be established without the member state's consent. In other words, such a provision related to investor-state dispute settlement is not to be considered as an institutional provision which does not give place to consider in an autonomous way the competence, but follows the regime of the competence for the substantive provision, but it is to be considered as a base of competence. Of whom? Of the member states. Because such a system, regardless of the question to know if it is compatible with the exclusive jurisdiction of the Court of Justice, regardless of that, touches the member state's competence and obligation to ensure what it was underlined in Opinion 109 about patent litigation. The member states have the loyalty obligation to ensure that the national judge will cooperate with the Court of Justice. In 109 opinion, it was an autonomy issue. The member states have to ensure that the national judge will cooperate with the Court of Justice because it's a part of a fundamental principle of autonomy. Here is the question of competence. The member states have to ensure that the national judge will cooperate with the Court of Justice. If the national judge does not cooperate anymore with the Court of Justice, It can be in conflict with the principle of autonomy, but it is not the question here. If the national judge does not cooperate anymore with the Court of Justice because the investor addresses the claim to arbitration, in that case, it is for the competence of the member state. We are in a field of the member state which have the obligation to ensure that the national judge cooperates with the Court of Justice. If the national judge does not cooperate anymore, then the member states have to approve such a provision of an international agreement. So it follows for the Court of Justice that the approval of ISDS provisions of the Singapore Agreement falls not within the exclusive competence of the Union, does not follow the regime of substantive provisions competence, but within a competence shared between the Union and the member states, not because it is linked to shared competence provisions, but it is an autonomous basis for competence considerations, for competence reflection. It is a competence shared with the Union, between the Union and the member states. The court said that it is a competence shared between the Union and the member states. However, it did not say that the provisions concerning shared competence cannot be approved by the Union alone. So several questions are raised here. First, does it mean that ISDS provisions may be considered as non-compatible with the jurisdiction of the Court of Justice and those with the autonomy claim? But if the member states intervene to approve such a provision, then there is no more problem with regard to the autonomy claim. Another question to be, in other words, the question is to know, can the action of the member states, can the competence question resolve the autonomy question? Consider that it is for the member states to approve such provisions. Does it mean that they may approve such provisions even if they are to be considered as in conflict with the jurisdiction of the Court of Justice and the fundamental characteristic, autonomy, of the Union legal order, that is, the national judge with the Court of Justice ensure implementation of fundamental principles of EU law. So, does the member state's competence compensate the autonomy claim question? It is not clear from the opinion 215. And not only it is not clear, but the Court of Justice explicitly underlined that it will not deal here with the autonomy question, but only with the competence question. Another question raised is the question of the nature of the competence. Does it mean that ISDS provisions of an investment treaty, of free trade agreement, fall under exclusive member states competence? The court said shared competence, but it didn't say cannot be approved by the Union alone. So it's a different position with regard to non-direct investment provisions. Said shared competence, but shared competence may be seen as a competence for the whole agreement. Some provisions exclusive EU competence, other provisions exclusive member state competence. So the question is, can we apply the COTIF judgments with regard to ISDS provisions and say that it is shared competence, but the Union may decide to exercise it. However, what is the objective? We don't have here a policy objective to assess the necessity to attain the objective. There is no policy objective, so what is the objective of these provisions? The objective of the ISDS provision is to ensure implementation of the agreement as a whole. So it is not a policy objective to assess the necessity to exercise a shared competence. So there are several open questions. What we can conclude already is that ISDS provisions, from a competence division point of view, fall under member state competence. Now, is it exclusive, shared, can be exercised by the Union? The question is open. The Court of Justice did not take position on that. Now, what about the autonomy claim? Can we consider that ISDS provisions are in conflict with the exclusive jurisdiction of the Court of Justice and not only of the Court of Justice, but the Court of Justice with the national judge, regardless of the question to know whether the member states may compensate this incompatibility through the competence to conclude, to approve these provisions. But can we consider that these provisions are in conflict with this fundamental characteristic of the EU legal order, which is EU law is applied through the cooperation between the national judge and the Court of Justice? This was the position of the court in the opinion about patent litigation, in the opinion about accession to the European Convention of Human Rights. It will be the question dealt with in pending opinion 117. But what are the elements we have already? We have some elements from the ACMEA judgment. Even if the ACMEA judgment concerns intra-EU bilateral investment treaties, the Court of Justice took a clear position with regard to the autonomy and the ISDS disputes, the investor state dispute settlement provisions. The ACMEA ruling is a judgment of March 2018 and concerns the compatibility with EU law of the provisions of a bilateral investment treaty between two member states, even if this agreement, this treaty, was concluded before the accession of a member state to the Union. So it was initially an investment treaty between a member state and a third state, which now became an investment treaty between two member states, what we call intra-EU BITs. So the request was a preliminary reference to interpret articles related to the principle of non-discrimination, something that the court did not address, but addressed the interpretation of Articles 267, preliminary reference procedure, and 344, exclusive jurisdiction of the Court of Justice to interpret and apply EU law. So we have a case before the German judge, who was the responsible judge in application of the investment treaty, concerning the implementation of an arbitral award in a conflict, in a litigation between a Dutch investor and the Slovak Republic, which had concluded the agreement. We have an agreement between Slovak Republic and the Netherlands, and recourse to an arbitral tribunal, an arbitral award to be implemented in Germany. So the question is to know, is it possible to admit the validity of such an arbitral award? In other terms, the question is, in other words, the question is, investor state dispute settlement, because we have investor, Dutch investor, and Republic of Slovak Republic, investor state dispute settlement from an arbiter. Is it compatible with EU law, which provisions, preliminary reference, and exclusive jurisdiction of the court? So the court is asked to interpret these provisions in order to enable the national judge to assess the compatibility of the ISDS provisions with EU law. So what is the position of the Court of Justice? First of all, we need to underline that the situation is somehow different from that of the pending opinion 117, because 117 concerns CETA, which is an agreement to be concluded by, is concluded by the Union. Even if it is a mixed agreement, it is an EU agreement. While in the ACMEA judgment, we have intra-EU agreements of member states. So the context is different, but the question is the autonomy and the compatibility of ISDS provisions with EU law. So what is the position of the court? It is maybe interesting to start from the end of the ACMEA judgment. the last 3 paragraphs. The Court of Justice recalled settled case law, according to which an international agreement providing for the establishment of the court responsible for the interpretation of its provisions and whose decisions are binding on the institution, including the Court of Justice, is not in principle incompatible with EU law. It's the same position as to the competence. The court has said in the 215 opinion that the competence of the Union to approve an agreement entails the competence to submit to a dispute settlement body. Here the court continues to say that in principle there is no incompatibility to approve an agreement providing for a dispute settlement body. It is not incompatible with the EU law. And recalls the competence of the Union. Its capacity to conclude international agreements entails this competence to submit to the decisions of international body. In the present case, however, let's see paragraph 58, which is a very rich paragraph. In the present case, however, apart from the fact that the disputes falling within the jurisdiction of the arbitral tribunal referred to in Article 8 of the BIT may relate to the interpretation both of that agreement and of EU law. Here we have an issue of incompatibility because, as it has been said in 191 already, an international body cannot apply and implement EU law, only the provisions of international agreement. So we may have this kind of incompatibility, that the arbitral tribunal applies EU law. Intra-EU BIT is to be considered as EU law. But apart from this fact, the court goes further to underline the constitutional dimension of the obligation of the member states, apart from this fact that the arbitral tribunal may apply EU law. The possibility of submitting such disputes to a body which is not part of the judicial system of the EU. What is the judicial system of the EU? National judge together with the Court of Justice, patent litigation opinion. No? So the possibility of submitting those disputes to a body which is not part of the judicial system of the Union is provided for by an agreement which was concluded not by the EU but by the member states. This is already the difference with CETA. So what is underlined here is the obligation of the member states to ensure that the judicial system of the Union functions. If the member states that do not ensure anymore this obligation, what is at stake is the principle of loyalty. The court continues. Article 8 of the BIT is such as to call into question not only the principle of mutual trust between the member states, but also the preservation of the particular nature of the law established by the treaties. And here we have autonomy. Call into question mutual trust, we will come back to this, but also the preservation of the particular nature of the law established by the treaties, ensured by the preliminary ruling procedure provided for in Article 217, and is not therefore compatible with the principle of sincere cooperation. In those circumstances, Article 8 of the BIT has an adverse effect on the autonomy of EU law. So it is a very rich paragraph to arrive to the conclusion that ISDS provisions of the BIT are in conflict with the autonomy of EU law. What the court says in these 2 paragraphs, first we have an affirmation. What is the affirmation? That ISDS dispute settlement, investor-state dispute settlement provisions may call into question the principle of mutual trust and the preservation of the particular nature of EU law. This is a fact because fundamental characteristic is national judge together with the Court of Justice. Arbitral tribunal is no more than national judge. So Article 8 of the BIT may call into question the preservation of the particular nature of EU law. What is the consequence? Violation of the loyalty duty, because loyal cooperation means the obligation to ensure the functioning of the system. What is the result? Contrast with the autonomy. If we take the reasoning from the other side, we can say that what means autonomy? Autonomy means the obligation of member states, the loyal cooperation obligation of the member states to ensure the functioning of the judicial system of the Union. Why? Because this functioning of the judicial system of the Union is the basis of the mutual trust, is a value, is a standard of judicial protection. And there we have mutual trust. So it is interesting to go somehow previously in the Acmea judgment, just to say that the Court of Justice did not deal finally with the exclusive jurisdiction of the Court of Justice. It is not that the problem. The problem was not to know whether the arbitral tribunal applies or not EU law. The court said, beyond this question, we have a more fundamental question. So it did not deal finally with Article 344. It referred to the distinction between commercial arbitration and investment arbitration in order to underline that in investment arbitration, there is the member state obligation which is at stake, because it's the member state that takes the commitment, while the commercial arbitration, it is private parties who decide. The Court of Justice underlined, so the obligation of the member states, stemming from Article 19 of the treaties. What is Article 19? The obligation of the member states to ensure effective remedies, to ensure that the national judge cooperates with the Court of Justice, and that is a standard of judicial protection. So, consequently, what is the position of the court? That there is a specific characteristic, autonomy, which is loyal cooperation with regard to the functioning of the preliminary reference procedure, which is a value, judicial protection, on the basis of mutual trust. And without mutual trust, we don't have EU law. So, call into question mutual trust, because we call into question the functioning of the system. It means that there is violation of the loyalty obligation, and as a result, there is a conflict with the autonomy of EU law. So this is the position of the Court of Justice in Acmea judgment. So the question is, can this position apply with regard to the CETA? What is the difference? At the very beginning of the reasoning, or at the very end, it depends how we see the reasoning of the court. What is it? Mutual trust, because we have a provision applying between member states. Mutual trust does not apply with regard to Canada. So this is the open question to know, can the reasoning in Acmea apply to the CETA context? Maybe not. Maybe there is only a question of competence and not a question of autonomy, but we cannot defend this conclusion as far as we don't have the position of the Court of Justice. For the moment, we can only discuss the elements we have, and what is important for the principle of autonomy is to see the link that the Court of Justice established with the principle of loyal cooperation to ensure the functioning of the judicial system, which is part of the autonomy of the EU legal order.